Judgment in the matter of Philipp against Barclays Bank UK.
Lord Legate will explain this judgment.
This appeal raises a question about whether a bank is liable to compensate a customer who is a victim of a type of fraud known as authorised push payment, or APP fraud, in which the customer is tricked by a criminal into authorising the bank to make a payment to an account which the criminal controls. In 2018, the claimant in this case, Mrs Philipp, and her husband, fell victim to such a fraud. They were deceived by a criminal who pretended to be working for the Financial Conduct Authority and the National Crime Agency. He led them to believe that to keep their money safe, they needed to move it to safe accounts. At the direction of the fraudster, they first transferred most of their life savings to Mrs Philipp's current account with Barclays Bank. Mrs Philipp then instructed Barclays to transfer first £400,000 and then another £300,000 from her current account to the bank accounts of two companies in the United Arab Emirates. The transfers were made and the money was lost. In these proceedings, Mrs Philipp has sued Barclays Bank, claiming that it is responsible for this loss. She contends that the bank owed her a duty under its contract with her, or under the common law, not to carry out her payment instructions if, as is alleged, the bank had reasonable grounds for believing that she was being defrauded. The bank applied to have the claim summarily dismissed, on the ground that as a matter of law it did not owe Mrs Philipp such a duty. The High Court agreed and dismissed the claim, but the Court of Appeal allowed an appeal by Mrs Philipp. The Court of Appeal accepted her argument that, in principle, a bank owes a duty to its customer not to comply with the customer's payment instructions if the bank has reasonable grounds for believing that the customer is the victim of a fraud. Whether such a duty arose on the facts in this case can only be decided at a trial. From that decision, the bank now appeals to the Supreme Court. For reasons given in the judgment that we're handing down, the Supreme Court unanimously allows the bank's appeal and holds that the bank did not owe the alleged duty to Mrs Philipp. APP fraud, the type of fraud which occurred in this case, has become all too common. Whether victims of such frauds should be left to bear the loss themselves, or whether banks which have made or received the payments on behalf of customers should be required to reimburse victims of such crimes, is a question of social policy for regulators, government, and ultimately for Parliament to consider. It is in fact now the subject of legislation. The Financial Services and Markets Act 2023, which received royal assent a few days ago on the 29th of June, makes provision for a mandatory reimbursement scheme, although this scheme does not extend to international payments and so would not have applied in this case. In the absence of such a scheme on which she can rely, the claim made by Mrs Philipp is based on her contract with the bank. The contract between a bank and a customer who holds a current account with the bank is a very well-established type of contract. Certain obligations have come to be recognised by the common law as obligations implied by law into contracts of this type. These ordinary obligations can be added to or altered by express agreement. It would be possible for a bank to undertake a duty of the kind alleged and to agree that it is not to carry out a payment instruction given by a customer if it believes or has reasonable grounds for believing that the customer has been tricked by a third party into authorising the payment. But the standard terms of business on which Barclays agrees to provide its services to customers do not contain such a contract term. Mrs Philipp argues that no such express contract term is needed, because a duty of this kind is either already recognised by the common law or can and should be recognised as an implied term of a contract between a bank and its customer. The Court rejects this argument. The duty proposed is inconsistent with the ordinary, well-established implied obligations of a bank. Provided that the customer's account is in credit, the ordinary duty of the bank, when instructed by its customer to make a payment from the customer's account, is to carry out the instruction and make the payment, In making the payment, the bank acts as the customer's agent. Its duty is strict. Unless otherwise agreed, the bank must comply with its customer's instruction and do so promptly. It is not for the bank to concern itself with whether the customer's decision to make the payment is wise or foolish. Mrs Philipp's argument relies heavily on a precedent, also involving, as it happens, Barclays Bank, a case called Barclays Bank against Quincecare Limited, decided in 1989. In this and other similar cases, courts have held that a bank which receives a payment instruction from an agent of the customer owes a duty not to carry out the instruction if the bank has reasonable grounds for believing that the agent is defrauding the customer and is trying to use the customer's money for the agent's own purposes. Our judgment explains that the rationale for these cases is that where a customer gives an agent authority to sign checks or give other payment instructions on the customer's behalf, this cannot be interpreted as giving the agent authority to act dishonestly and in fraud of the customer. If the bank were to carry out such a dishonest instruction, it would therefore be making a payment which the customer had not actually authorised. Even then, the bank would still generally be entitled to rely on the agent as having apparent authority to give the instruction on behalf of the customer, but not if the bank has reasonable grounds for believing that the agent is trying to defraud the customer and is therefore not authorised to give the instruction. In that case, if the bank executes the instruction without first making inquiries to verify that the payment has actually been authorised by the customer, the bank will be in breach of duty. It will also be acting without any actual or even apparent authority from the customer and will therefore not be entitled to debit the payment to the customer's account. This reasoning does not apply to cases like this one, where there is no agent involved and the customer herself personally gives an instruction to the bank. In this situation, the validity of the customer's instruction is not in doubt. Provided it is clear, no inquiries are needed to clarify or verify what the bank is authorised to do. Unless otherwise agreed, the bank is authorised and obliged to execute the instruction, and any refusal or failure to do so will be a breach of duty by the bank. In this case, each of the two payments made by the bank to bank accounts in the United Arab Emirates was made after Mrs Philipp had visited a branch in person and given instructions to the cashier to transfer the money from her current account to the foreign bank account in question. On each occasion, before the payment was made, a representative of Barclays telephoned Mrs Philipp to seek her confirmation that she had authorised the payment and wished to proceed with it. On each occasion, Mrs Philipp gave the required confirmation. It is not in dispute, therefore, that she unequivocally authorised and instructed the bank to make the payments. In these circumstances, it is impossible to say that the bank owed her a duty not to comply with her instructions. Mrs Philipp has an alternative claim that the bank was in breach of duty in not acting promptly to try to recall the payments after being notified of the fraud. In the court's view, the questions 1, whether the bank owed such a duty, and 2, whether there was any realistic chance that the money would have been recovered if attempts had been made to recall the payments sooner, cannot be decided without a full investigation of the facts, which will require a trial. In the result, the court restores the order of the judge granting the bank summary judgment, but varies the order to permit Mrs Philipp to maintain her alternative claim based on the bank's alleged failure to act promptly to try to recall the payments after the fraud was discovered.